Helping Seniors Television, all about improving quality of life for seniors. If you're a senior, know a senior, or plan to be a senior, then this show is for you. It's all about helping you develop your own aging plan so you can age actively and with dignity. Helping Seniors Television from the Helping Seniors Network of information, education, and resources.
I'm Kerry Fink, and on behalf of Joe Steckler, the president and founder of Helping Seniors of Brevard, and our entire Helping Seniors team, welcome to Helping Seniors Television. Today, we're going to take a look at a word that everybody needs to know a little bit more about. Number one, because if we don't plan well, we're required to go through the process. And if we do plan well, we may be able to avoid the process. And the word I'm talking about today is probate. So it's 7 letters, but there's a lot packed into those 7 letters. And I have the privilege of having longtime Helping Seniors friend Bill Johnson, board certified elder law attorney with William A. Johnson, PA. Hey, Bill, how are you?
Good, Kerry.
There is a lot packed into that word, and for most of us, I'm not even sure we hear that word bandied about, but I don't know that we even know exactly what that means.
Well, that's a good lead-in. Probate actually comes from Latin meaning to prove. And what are we proving? We're proving the will is valid. So it's a process where you take a will to the courthouse, and then you go through a process where the court accepts the will, and that's what we're proving. The will's valid, and we give notice to everybody, and then once the court accepts the court will then appoint the nominated personal representative, which is Florida's word for executor, and then the probate is off and running. So probate comes, like I said, from the Latin word to prove, and in Florida, like you said, we want to avoid probate. And why do we want to avoid probate? Typically, it can last 9 to 12 months. It costs a lot of money. Someone like me could charge 3% of the assets going through probate. That's on the first million, then it gets graduated down later. The personal representative can charge 3%. You have your filing fees, you may have accounting fees. So it can add up very quickly. On $1 million probate, my fee would be roughly $30,000.
Wow.
So there's a lot of good reasons to avoid probate.
And when you think about, people say, well, I'm not a wealthy person. I don't have the plantation with all the trees and things like that. I just have a home. But nowadays, your home could really push you up into those kind of numbers anyway.
Correct. And you don't want to have to just probate a home or a $500 bank account, because the costs of doing the probate alone are discouraging. So, not only do you have the attorney's fees, you have the filing fees, and subsequently, most people don't want to get caught up in the probate process.
Well, it's also time consuming, right? Because you have to go all through these court processes and things like that as well.
It's very time consuming, and a lot of it is not how quick someone like me can do the paperwork, but a lot of it is, getting appraisals on the house. There's a 3-month built-in creditor period that we have to wait until that expires. Then everything we submit goes to the courthouse. It gets reviewed, all before it ever goes to the judge to get the judge's signature. So all those things create delays in the process and subsequently extend the process 9 to 12 months.
Now, let me ask you a question, because all this presumes that somebody has a will. Now, if somebody dies without a will, that's probate still applies, right?
It could. That would be what we call an intestate probate, meaning you do not have a will. There is a statute in Florida that determines then who would get the assets going through probate. But again, not all assets go through probate. So there is some ways to avoid probate with your assets and subsequently avoid all the costs and delay of a probate process.
Yeah, and before we get into some thoughts on that, I wanted to ask this question because I was thinking, so if somebody says, well, I have a will, maybe they went down to the Office Depot place and bought a form or something, or maybe they went someplace online and found a form and said, oh, this is my will, that doesn't get them around this probate process at all, even if that paperwork was correct.
Correct. A lot of times I get people in my office and they say, well, we've got this will, and I thought wills avoid probate. And nothing could be further from the truth, because I explained what the word probate means, and wills are what go through probate. So that is the definition of what would go through probate.
So whether you have a will or you don't have a will, but you have something of value like a home or something like that, you're almost going to be required to go through probate unless you've taken some steps in advance to think your way through that.
Correct. And some of it could be very simple planning, others could be more complex. It depends basically on what your assets consist of, on how complex or how simple you can make the process to avoid probate.
Now, a lot of times people will say, yeah, but I just don't have all that much. Is this really something I need to fool with? You know, I've got my house and I have maybe a little 401k or something like that. Is there a point that people should think through that? Because I've heard other people say, oh, I'm just going to put the kids on a bank account or something like that.
Well, that's, you know, there are a couple ways you can avoid probate. One of them is through the use of joint title that has survivorship rights. Another way is you can put a beneficiary on it. So you mentioned a 401k. Traditionally, that has a beneficiary designation. Or you could create a trust and put your assets in the trust. And because we have this agreement, when you pass, then somebody puts on the hat as the successor trustee. And when they do that, they agree to be bound by the terms of the trust document, and they are supposed to act on behalf of the beneficiaries and do what the trust says. And because we have this alternate way of doing it, we don't have to go to the court to do it. So there is an alternate mechanism with that.
Well, and that also seems like that would be a far more intelligent approach than simply willy-nilly trying to come up with little solutions on your own.
Well, you gave me a perfect example earlier. Say you had a joint account. Now, if you're married, you probably own most of your accounts as husband and wife. So if one of you passes, it will go to the survivor, typically. Okay? And in Florida, bank accounts are presumed to pass to the surviving owners of the account, absent fraud, undue influence, or a contrary donative intent. So if you're married, you probably own most everything jointly, with the exception maybe your IRA or 401k, which is only in your name. So usually on the first of you to die in a marriage, everything passes to the surviving spouse. However, when the surviving spouse dies, then we have to look to the surviving spouse's will. You mentioned adding kids' names to accounts. The problem with that is, what if your kids get sued? They could be in a car accident. I've had that recently in a case. They could be sued on a business relation, things like that. So you don't want to add kids' names necessarily to your accounts as owners or to your house as an owner. In Florida, your homestead is protected from creditors' claims. Now that is defined as your residence. Now if your kid's name's on the house and they don't live there, now all of a sudden part of your house could be up for grabs by a creditor. So there are usually better ways of doing it, because joint title a lot of times only just forestalls the inevitable probate, especially with married folks. The other way I mentioned was beneficiary designations. So we talked about a 401k, IRA. You could name your spouse and then your kids typically as the beneficiaries. And when you pass, all they have to do is bring a death certificate to whoever administers that plan, and they will pass the assets on to them. And usually the spouse can roll it over into a IRA in their own name, or if it goes to the children, now they have changed the law, it's usually a 10-year disbursement out to the kids. Now, that said, you can also put beneficiaries on other assets. Annuities, life insurance are common ones. Bank accounts. you can go to the bank and make your bank account payable on death, so that when you pass, all the heir has to do is supply a death certificate and their account's theirs. So say you were married, you could own a bank account, husband and wife, payable on death through your 4 kids. So when one of you passes, it would go to the surviving spouse by virtue of joint tenancy. Then when the survivor dies, by virtue of the pay on death clause, it would go to your heirs. And all that has to be supplied on the first spouse's death is a death certificate to the bank, and they'll put it in the survivor's name. And then when the survivor dies, the kids would supply the second death certificate, and the account would be theirs. You can do the same thing with a brokerage account, except in the world of securities, it's called transfer on death. Mm-hmm. So you can designate who you want as a beneficiary of your brokerage account, and you do that through your broker. If you have certificates, you would actually have to do it through the transfer agent. If you have government-issued bonds, you're going to have to send them back with instructions to add this to the Treasury Department. But you can put basically transfer on death.
I've heard that, yeah, I was going to say, I'm glad you mentioned that, because I've heard those acronyms before, POD and TOD, and I was thinking that must have something to do with this whole way of excusing from at least those accounts from that aspect of probate. But one of the things that you've taught us along the way, and I want to remind you, viewer, if you're thinking about this topic, that there is a wealth of TV programs that you want to investigate on the Helping Seniors website at helpingseniorsofbrevard.org. You can go directly to the Helping Seniors YouTube channel. And I want to encourage you to specifically put in the search bar Bill Johnson and put Elder Law Bill Johnson, because what you will find is a plethora of programs that are going to come up, and they're going to hit a number of these topics that are going to be relevant to thinking about estate planning, Medicaid planning. There's lots of information you want to access. And the reason I'm bringing that up is because one of the things that you've taught us along the way is that these things don't operate in a vacuum. So while you're planning, you may think, I've got everything tidy up in a will. You may have to think through issues that may come along even before a will, like Medicaid planning or VA planning or just the things like that. And I want to basically ask you, when you're thinking about the strategy of probate, some of that must come into how you talk to people about their particular situations.
A good example is in Medicaid planning, if we're applying for somebody, the patient can only have $2,000 in assets, excluding house and car. The spouse can have up to $128,640 for the year 2020. and subsequently, if we have all their assets, say, in a joint trust, all those assets count to the patient, which can only have $2,000. So we may have to bust up the trust that we did to avoid probate for purposes of making somebody eligible for Medicaid. And that's not uncommon that we have to do that.
And then not only that, I've also understood that, if the person says, no, this is the person I really want to see benefit from what I've been able to accumulate, but you have to be careful with that, again, with respect to the Medicaid planning, so what you have as your end goal in mind doesn't harm you on the way to that end goal.
And as I mentioned again, the patient can only have $2,000, so if I have a spouse that has assets, we don't want them to name the other spouse as the beneficiary of those assets, because if they die first, everything goes to the one who's on Medicaid and knocks them out of the program, and we have to start all over again.
Yeah, we've had this conversation so many times. This is why really sitting down with somebody who understands all the subtleties and the intricacies of this is so important. And I guess it's also a reason why somebody at the end of the day really does have to sit down with you and say, well, here's where I'm at, here's what I've got. Now help me put the puzzle pieces together the right way.
And there are two assets that I typically get talked about, because I explained you can avoid probate with joint title, you can avoid probate with beneficiary designations. And the first thing people say is, what about my car? Mm-hmm. And what about my house?
Right.
So with your car, under Florida law, if the car is titled in your name and you pass away and it's solely in your name, we can actually take the will, a death certificate, and the title to the car to the tax collector's office, and they will transfer that into whoever the will says should get it. And it could be even if you just say, I simply leave everything to my spouse. That's good enough. And the reason for that is the car is exempt from creditor's claims under Florida law. So we don't necessarily have to probate a car. There is a simple way around it without going through probate. With the house, believe it or not, you can actually add beneficiaries to your house. And there are two ways of doing that. One is you can transfer your house to your kids and retain the right to live in your house, which is a traditional life estate. And the second way is something called a ladybird deed or an augmented life estate deed, which operates pretty much like a pay-on-death deed, meaning that you say, I'm going to transfer my house to the kids, but right now I'm going to retain the right to live in it, and I'm also going to retain the right to do anything I want with it, including sell it, transfer it, mortgage it, without having to ask permission from the remainder people, the people who eventually will get it. And this operates like a pay-on-death deed. So if we had a house that was in my name only, and I had one of these ladybird deeds, when I die, the funeral home or my children would record a death certificate, and the house would automatically transfer to them. So there is a way to even put beneficiaries on real estate.
Wow.
And so you can, again, going back to the very first question you asked is, what kind of plan is there? Well, if I have somebody who has very few assets, let's say they're renting a house and they only got a couple bank accounts, I'm going to tell them, go down, add the kids as beneficiaries on your bank accounts, boom, you're done. You don't need me to do a trust for you, that kind of plan. Now, if I have somebody who has a lot of assets, then we have to kind of look at how complex is that? Because a lot of times I can still do it with just beneficiary designations.
Wow.
Now, the reasons you would want a trust, there are several that would automatically trigger that. If you had real estate located in another state, for example, I have a lot of clients with real property in North Carolina. Well, North Carolina, you cannot do the ladybird deed there. So subsequently, we have to do a trust and put the real estate in the trust to avoid probate in North Carolina. Another reason would be, say your kids are spendthrifts. They spend everything they get. And instead of giving the money outright to them, you want to dole it out over time. Well, then you're going to have to create a trust to do that. Because a beneficiary designation, you're just going to drop it all right in their lap. And if they're minor kids, that may not be such a good idea because they'd get all that money when they turn 18. And we probably all knew somebody in high school who inherited a lot of money, and then a couple of years later, they didn't have any money because they bought the cars and everything else. So if you have minor kids, spendthrift kids, if you have special needs kids, we may have to do a trust just because we may not want to knock them off of public benefits and keep their eligibility going. So there are certain reasons why you would do a trust instead of trying to rely solely on beneficiary designations.
And, you know, that's another point when you talked about people with homestead or, well, homes, you know, because here in Florida, in other states, because here in Florida, so many people are from other states. It's actually not all that common that you meet a true Florida native. Most of us got here by the grace of God, and here we are in Florida. But, you know, I was thinking about that. That must make it really complex when you're helping somebody sit down and figure out they may be snowbirds, for example. They may do something up north during, you know, the winter months and, during the summer months and then come down here and enjoy winters. And so all that has to be factored in as well.
That's a fantastic question because Florida is such a great state to retire in. We do not have an income tax. We do not have an estate tax. We do not have an inheritance tax. Unlike a lot of states, especially in the Northeast, where we get a lot of retirees coming from. So if you have somebody, say, from New York who retires to Florida, we want to redo all their documents specifically saying that they are now a Florida resident, even if they own real property still in New York, because we want to make it abundantly clear that they are residents of the state of Florida, including getting voter's ID and driver's license, because states like New York, New Jersey all have estate taxes, income taxes. And so if they pass away, a lot of times those states are very aggressive in trying to pull the estate back into New York so they can get a cut of the estate.
You know, and that also is another point that probably is worth thinking about. Maybe if you spent your life in another state during your working years and you're coming to Florida and you come here and you think, well, I've really done all this well. I got all my documents, a very good law firm in such and such a city helped me put this plan together years ago. That still doesn't mean you're home free when you get to Florida, does it?
It does not. We do have a statute that says we will recognize an out-of-state will and trust if they were valid in the state you move from. But a lot of times that's not necessarily the problem. As I mentioned, having to do probate in multiple states because you own real property in multiple states. And also that tax issue I just talked about. You know, if you own property in New York, and are they going to tax it before they'll release it to a Florida personal representative? So there are a lot of issues. We generally advise people, you know, if you're moving to Florida, you're going to be a Florida resident, move all your accounts here, move your banking here, move everything to Florida so there's no doubt who has jurisdiction.
Boy, that seems really important, particularly because I know a lot of people cash in, from the cost of the North or something like that and say, wow, I can really have my money go far, in Florida, relatively speaking. But it seems like all these things that you're talking about, you have to take into account, because otherwise, going back to our original point of this program, talking about probate, it seems like it's one of those, they love to tell us things like if you plan to fail, or if you fail to plan, you've planned to fail. But it really, as you talk about it, it's your own money we're talking about, and you're going to fail with your own money.
Well, one of the things is, obviously, you're going to be gone when this all happens, right, because you'll be in the grave. Right. And subsequently, some people really don't care what happens after they're gone. Frankly, they are like an ostrich. They like to keep their head in the sand. Mm-hmm. However, if you don't want to leave a huge mess for everybody, you can do some very simple planning, and I've outlined that, with joint tenancies with rights of survivorship or with beneficiary designations. If you don't have a lot of money, it's pretty easy to do that kind of stuff. And if you have more complex kind of estate or a large estate, maybe you want to consider doing a trust. Mm-hmm. I had some people in the other day, and it was a large amount of money, and they didn't want to necessarily just give it lump sum to the kids. They want, the kids to get it over time so they don't blow it.
Right.
So some of those considerations need to go into the planning.
And, as you're talking about things like that, what keeps going through my mind, because I've heard you and Joe talk about this on radio shows and TV shows over the years, where he'll talk about the fact that sitting down and putting the documents that you need to get all this right is very, very minimal in cost relative to what it costs on the flip side if you don't have all this in place.
That's a very good point, because yes, on the flip side is where it gets expensive. And, I'm not trying to toot the horn for attorneys here, but I have seen people come in my office with wills or trusts they do online. They get them, they take them home, and then they sign them, and they think the witness lines are optional. And subsequently they think they're covered. They think they have a will, they think they have a trust, and in fact they have nothing because they didn't sign it in the presence of two witnesses who watched them sign and attested to that. So I'm getting all kinds of documents and forms that people have executed wrong. And that, if nothing else, when you go to the lawyer's office, hopefully everything's going to be executed correctly, right, and you're going to have what you think you have. because these people thought they were covered. They come in, and I'm like, this isn't even a valid will, and they never realized that.
How many times do we see a news story, right? Some famous performer passes away, and all of a sudden 15 copies of a will come out of the woodwork. And
right.
Obviously,
right.
each one has the money going to somebody different.
Right.
And it seems like there's so many ways that, and I assume when stuff like that happens, all bets are off when you come to probate. So doesn't it make sense to just sit down and do this the right way one time, get this organized, have your documents ready?
And more importantly, probably do it while you're healthy and of sound mind,
right,
instead of waiting to the 12th hour.
Yes.
I've had several people lately who have terminal diagnoses who have put off getting or finalizing their documents, and before they've got them signed, they passed on.
And if you want to, yeah, and so then if you had an idea that you really want to do something correct with what you have, you got to do it before the time's too late. Well, we're almost speaking of time, we're almost running out of time for today, but I want to make sure that people understand that they can get in touch with your office and you're willing to sit down and take a look at somebody's situation and sort of get them pointed or say, this is the plan or this is what I would do next. And that first step really doesn't cost anything other than the time to come in and sit down and say, well, here's where I'm at and here's what I'm looking at.
We do free consultations, yeah.
So how do people get in touch? Is there a phone number or what's the best way to reach?
The best way is probably to call our office. It's 321-253-1667. We also have a website, which is floridaelderlaw.net, all spelled out.
That's good. And folks, I want to brag on Bill here because he's not only an elder law attorney, but he's a board certified elder law attorney. And so if you want to talk to somebody that really can help you understand the ways to avoid probate, give Bill's office a call. So thank you, Bill, for being with us today.
Thank
We're
you.
kind of run up against the time, but I want to invite you to take a look at the different programs that have been available on the Helping Seniors YouTube site, and you'll find really good elder law information that will help you make your own aging plan. Thanks for joining us for Helping Seniors TV today.
I'm Joe Steckler. Thank you for joining our program today. I'd like to remind you that our senior information line is available to you at 321-473-7770. There you can get help and direction that could be helpful for your specific situation or circumstances. The work of helping seniors is very important, but we can't do it alone. That is why our sponsors here in Brevard County are so important. I'd like to thank our many area sponsors, businesses and medical providers who support the mission of helping seniors that help us carry the cost of our media efforts. If you'd like to join us either as a business partner or simply donate as an individual, we would welcome your call at 321-473-7770. You are always welcome to visit our website at www.helpingseniorsofbrevard.org. Thanks so much for your help. It does make a difference.